Hi, very good morning. Another interesting judgment from Delhi High Court. Karamsar Poultry Appliances versus Assistant Commissioner. Issue before the court was once the order is set aside by appellate authority, is the consequential relief because the order is set aside. So the consequential relief is it automatic or not? That is the question. Facts. So the petitioner he claimed refund of unutilized input tax credit. A show cause notice was issued for rejection of the refund. So petitioner submitted his reply. Refund claim was partly allowed and partly rejected. If it is 100 rupees, 50 rupees allowed, 50 rupees rejected. Then petitioner filed an appeal against the rejection of the refund claim. That part, that 50 rupees. Appellate authority set aside the order of the assessing authority. The appellate authority said, the appellate authority set aside the order to the extent of the refund amount wrongly rejected by the assessing authority, the original authority. The assessing authority, after his order was set aside by appellate authority, re-examined the case afresh. Again, he rejected the claim of refund. That 50 rupees again I will not grant, even though that order was set aside by the appellate authority, initial order. In the order rejecting the refund claim, the authority said, proper officer is duty bound to verify the admissibility, correctness, and quantification of refund claim. Claimant has not satisfactorily established a clear and verifiable correlation of rectifications with the returns. Refund amount claimed is not computed on basis of accurate turnover figures. So claimant failed to substantiate the eligibility of refund. On that ground, he rejected it. This was challenged before the Delhi High Court, saying that the order is non-est. Delhi High Court said, appellate authority merely set aside the rejection of refund order. The appeal order neither directed unconditional release of the refund nor foreclosed the examination of the petitioner's entitlement on any other legally permissible ground. That is, no specific direction has been given. Only he has set aside the order. So the assessing authority cannot be said to be precluded from examining the claim afresh on the grounds distinct from those which stood negated by the appellate authority. Whether such exercise is valid or not, that would require examination on merits in the appeal. So court said it is unable to accept the argument that the order is non-est or without jurisdiction. However, it permitted the petitioner to file the appeal. You go and file the appeal. That is what the court said. My comments. When an order is set aside by the appellate authority, is not the relief, the consequential relief, automatic. Once he sets aside the order, that means the grounds on which the petitioner has filed the appeal, that has been accepted. So the refund is it not automatic? That is my question. One. Two. Is not the order of the higher authority binds the lower authority? Suppose tomorrow, if the high court sets aside the order, can the lower authority again examine afresh the case and issue a fresh notice on a different ground? Then where is the end to the cases? So one after another, you go on passing any order, I will go on issuing fresh notice on the basis of a different ground. I will go on issuing. So if the original orders are set aside by higher authorities, the third point, there is an appeal mechanism which is given. So department can always file an appeal against that order, bring everything to the notice of the tribunal and get that order of the appellate authority set aside by the tribunal. So is that appeal mechanism a waste? which is available in the statute. Because the authority is, you pass any order, sir, I will issue a fresh notice on a different ground. Finish. He will escape. So where is the end to all the tax law, cases? So anyway, this judgment is a good judgment as far as the tax consultants are concerned. That is what I feel. Thank you very much. Have a great day.